And generally what we cover, just overview of probate court. A lot of people look for their probation officer. We're not quite that, except for our problem solving courts. We'll talk about estate planning for everyone, touch on elder law. And probate court also has jurisdiction over civil commitments. And we will mention that. Again, mental illness and alcohol and drugs affects all of our families. And we've got Taylor joining. And give you some points to ponder, some trivia, and some maybe give you some bad jokes or two. See if you can get you to smile this morning. All right. Again, here's a recap of our topics: estate planning, elder law, our different probate court divisions, and then our problem-solving courts, and then estate administration. Some of you have lost loved ones, and we'll talk about the summary proceeding, normal administration, and contested cases. And here's an organizational chart, which is important. If you are probating an estate, you can see the different the estate division on the far left. I've got a clerk of court, Allison Atwood, and then 5 estate clerks. So if you're probating an estate, one of the estate clerks will help you from beginning to end. And that way we find it best that they help one family, and they are there to help you. And when you finish up, or if they're out and you come at lunch or something, the other clerks can also help you. And if you know anybody looking for a job, we're like everyone else. We're looking for employees. So if you know somebody looking for a job, please let them know. Just send a resume to me. Okay. State division, we've got about 2,200 estates, about 35 are open at any one time. Generally takes 8 or 9 months. We'll look at that, probating an estate. Next area is our commitment guardianship division. We want to avoid the guardianship by the use of a healthcare power of attorney, and avoid the conservatorship by the use of a business power of attorney or a trust. And then we've got 4 problem-solving courts, and then we have marriage license division, one of our happier areas. And then we have law clerks and support staff. And Jamie Robinson's been so nice to organize everything here today. She's our estates project officer. Oh, somebody else joining. And here's our staff contact information. I grew up in Conan's department store, and customer service, customer always right. And so you can get directly to the clerk that's needing to help you. You've got their direct dial number and also their cell number if they're working from home, and then also their email address. So just keep that in mind. And if somebody wants to record, they are allowed to record. And we also do record these workshops. And you can't reuse my bad jokes, though. All right. Who's been in a courtroom before? Anybody been in a courtroom? Okay, raise your hand if you've been in a courtroom. Okay, looks like some people have. Got a lot of speeders here today. Okay. No, what's the rule for jokes in a courtroom? 2 rules. Only the judge tells them. And then the second rule is what? You always got to laugh. So if I tell a bad joke, you got to laugh. Anyway, there's our staff contact information. You can go directly to an individual without having to go through our switchboard. And we are here to serve you. Let's see what else we got. And we're located down at the Four Corners of Law. If you're coming in person, you're welcome to come in person. The estate division's on the 3rd floor of the historic courthouse, and the commitment division's over here down on the bottom right on the 4th floor. The Four Corners of Law was given by that name by Robert Ripley, believe it or not. You've got the municipal law, local law, state law, and federal law, and then the highest law on the other corner with the church. Then and now it used to be the state capitol in Charleston before it moved to Columbia. It's done by an Irish architect by the name of James Hoban. And here we are over in Ireland dedicating a monument. That's my son in the plaid pants. The pants our luggage didn't make it there, so I had to buy some pants. He's not quite sure what to do with the Irish girl there. But anyway, when you look at the White House on TV, remember it's a Charleston architect. President George Washington visited our city in 1791, liked the work he did. And then Hoban beat out the likes of Thomas Jefferson to do the White House after doing our courthouse, and he modeled it after the Leinster House, which is a national parliament building in Ireland, in Dublin. All right, so again, the estate division is on the third floor of the building on the left, the historic courthouse. In the fourth floor on the right is where our commitment division is. That's where you get marriage licenses, and then civil commitments and guardianship and conservatorships. Estates are on the left there. All right, what's the highest basketball court in the land? You got the NBA playoffs going. What's the highest basketball court? If we're in person, I'll be giving away candy bars. Not in person, we'll have to mail it, I guess. The answer is the Supreme Court. Did you realize above the U.S. Supreme Court is a basketball gym? And I made 2 shots there and retired. So that's the highest basketball court in the land. All right, I think I try to make you smile. I know probating an estate, particularly for a loved one, is difficult. One of the first estates I did was my dad was in law school with the help of an attorney. And I recently did my mom's and my brother's. So I know it emotionally can be difficult, and that's where an attorney can help you. And we'll talk a little bit later about selecting an attorney. This was my mentor, Morris Rosen, also Ms. Robinson's mentor. Jamie and I have been working together. Jamie was at 30 years, and we worked for Mr. Rosen before coming over to the probate court. And he worked very hard. He rented space in the building on the right, the Hat Man building, ended up buying the building. He believed in hard work. Let's see, a question in the chat. Thank you. And
excuse me, Judge.
yes.
Erin, I'm so sorry. Erin Kiker needs to join the Zoom. I wasn't sure if she has done so yet. She just sent me an email.
Okay, I don't see her in the, well, we got a couple more coming in, right?
Yes, sir.
Here we go, sorry. We got a couple of individuals joining us, welcome. We just talked about the probate process. We'll send you the entire PowerPoint. Okay. Welcome. But anyway, we're now discussing estate planning, and we don't want your will to look like this. This is the will that actually was filed in the court. Of course, we took the name out to show you, and then the witnesses' names. Basically, one sentence. We never know when God's going to call us. On the right, there's sort of a shopping list. On the left, there's an actual will, leaving everything to his wife. So we want to make sure we get a will and get with an attorney in doing our estate planning. And Jamie has sent you the different documents. Let's run through these, and I'll try to discuss each one. First, we want to start with an estate planning checklist or questionnaire. That's what attorneys will use. We want to learn a few terms today. And the first is the difference between a probate asset and a non-probate asset. A probate asset is controlled by the will or the intestacy statute if you don't have a will. And then a non-probate asset is controlled by a third-party contract. Examples of that are, say, life insurance where you designate a beneficiary, a joint account with right of survivorship, a deed which is joint with right of survivorship. Those are non-probate transfers. They can, but don't have to be listed on the inventory and appraisement in the probate of an estate. But anyway, you want to list those, all your assets, on a checklist or questionnaire for your attorney. And that way they can decide the best way to carry out your wishes. Their wishes, I mean, your wishes are what the attorney has to do. That's what their duty is to carry your wishes. And they can do that through non-probate transfers. or they can do it through a will. Again, it's just like if you're driving someplace, there may be two different ways you can go. It's the same in doing estate planning. But everyone should have a will and a trust. Everyone should have a will and a trust. And we can do that one of two ways. If we look at number 2, we've got a last will and testament with a trust. The purpose of a trust is another vehicle. It holds assets until an individual can manage those. An example would be if the assets are going to a minor, when the minor is under the age of 18, the assets would be held in a conservatorship at the court until they reach the age of 18. And once they reach the age of 18, the court is required to give them those assets. And many times it's $100,000. Can an 18-year-old handle that assets? We're not sure. We hope they can, but in many cases they cannot. So we'd recommend that you put it in a trust. And in the trust can be inside the will. They'd get 1/3 of the assets, say at 25, 1/3 at 30, and 1/3 at 35. So hopefully they learn along the way and don't blow all of their inheritance. Again, you can have invasion powers for education or for medical needs. The most restrictive I saw is the child couldn't get the money until age 65. And I think the parents there knew that they had a child that would spend everything, and they wanted to make sure she had Social Security before she got all the assets. If we look down at number 6, another way to do this is through a revocable living trust. It's a separate vehicle. We put all of our assets in there and we manage those during our lifetime. And then at death, it acts as a will substitute. And in that trust document, we'd indicate who receives what and when. Even if you do a revocable living trust, put all your assets in there, the attorney will also have you do what's called a pour over will. And that's in the event that you don't put everything in the trust. When you pass, you can go through probate and pour any asset not in the trust back into the trust or into the trust for the first time. So we want a will with a trust or a revocable living trust with a pour over will. Most South Carolinians are fine with the will and a trust. Our probate fees are not that expensive. It's $95 on the first $100,000 of assets. The other thing a will does is allows you to name the person in charge of your estate, now known as a personal representative. Used to be called an executor, executrix. You can still use that same name. You can also, in the will, devise property directly to an individual, say real estate. And if you look at the will that we passed or sent to you, I think it's in paragraph 2, there's a reference to a memorandum of personal property. So if you've got jewelry or golf clubs or fishing rods, you can write on a separate piece of paper who's going to receive those assets. Again, the memorandum for personal property is only good for personal property, cannot include cash, and cannot include real estate. But it's a nice way of not having to come back to the attorney each time to update your will if you change who's going to receive the personal property. Again, a last will and testament has to be witnessed by 2 independent individuals. If you use family members, then they can only receive what they would receive under the intestacy statute. And to make a will, it's less than making a contract. To make a will, you have to know the objects of your affection, generally your friends and family, and then 2, know who you want to leave it to, probably family and friends, and then generally know what you own. So it's sort of a 3-part test. Don't have to know specifically what you own, but generally what you own. And if you have a lucid moment, you generally can execute a will. Again, the capacity to make a will is less than that to make a contract. Let's look at some other documents. The next is its financial size business durable power of attorney. This allows us to avoid the conservatorship. If I'm incapacitated, battling one of my 15 kidney stones in the hospital, and I can't pay the bills because I'm under medication, my wife, through the power of attorney, can pay the bills. If I didn't have that power of attorney, we'd have to come to the court and get a conservator appointed. And that can be an expensive process because you generally have an attorney bring the action. By law, we have to appoint an attorney and guardian ad litem to look after the alleged incapacitated person's rights. We have to have an examiner, court hearing, court reporter. You can see that that can cost a little bit. So the easier way is to go ahead and do a durable power of attorney. And it's durable because it still is effective even if you are incapacitated. Along those same lines, we've got a healthcare power of attorney, someone that we can name to handle our medical and healthcare decision making. Again, the healthcare power of attorney is a little bit different. It's actually a statutory document right out of our code of laws, and it allows us, allows our healthcare workers, our doctors, or EMS workers to see the same document each time. Even though it's a statutory document, it has great flexibility in it, and you can go from maximum treatment to withdrawal care. You can address organ donation. There's a series of rights there. You can put it in your own words. You can make a decision concerning nutrition and hydration. So the healthcare power of attorney, very useful estate planning tool. I would go back to the business durable power of attorney. It's the one document that has to be recorded to be effective, and it's recorded at our Register of Deeds office. The healthcare power of attorney does not have to be recorded. When we get to end of life, we have a number of decisions we can make, and one is this declaration of desire for natural death, also known as a living will. It gets confused with the living trust. The living trust deals with property. The living will deals with making end of life decisions. We've all seen the cases nationally, Karen Ann Quinlan, Terry Schiavo, Nancy Cruzan is the one that came about with this case. She was a young lady in her 30s, involved in an auto accident, ended up in a ditch with the head water. She didn't have oxygen to her brain for several minutes. The hospital's in business of keeping us alive. She had stated verbally that she did not want to be kept alive in that condition. Case went all the way up to our U.S. Supreme Court. They said you could withdraw the life support, but it's such a step that you're taking that it needs to be in writing. So that's why we have this written statutory document called a declaration of desire for natural death. The beauty of the document is it takes the decision-making, that burden off of your family, and it allows you to express your wishes. Along the same lines is number 7 there, and that's the 5 wishes document. If you Google that, you can get to the website for Aging with Dignity. It's a nonprofit out of Florida, and they allow you to download that for $5. What are the 2 certainties in life? What are those? Death and taxes. We talk about taxes all the time and complain about them, but the death and dying we do not talk about, and that's the whole purpose of this nonprofit, is to get us talking about death and dying, and to make those wishes known, how we want to be treated, who we want to make those decision makings. Take a look at the 5 wishes document, and you can have each of these documents. You just want to make sure you're consistent in your decision making. All right, what's Florida known as? What's their nickname in elder law? Take a guess.
The Sunshine State?
It's not Sunshine State, not in elder law. Yes, it is. It's known as God's waiting room in elder law. Okay. I hope you like my bad jokes anyway. Yeah. And those that move from the Northeast down to Florida and then move back to the Carolinas, they're called what? They're called halfbacks. They move halfway back. You know, like this. So you may fall in these categories. Anyway, let's get back to the material here. Another document that can be very useful, executed by a doctor or doctors, is a do not resuscitate order. I lost a brother several years ago to cancer. He knew the cancer had him and he was going to die in a matter of days. He executed with the doctor the DNR. In case he had a heart attack, he could go ahead and pass rather than suffer for several more days. So all tough decisions we have to make, and all decisions that we can make. But in many ways, it takes the burden off of our family members from having to make that decision, letting them know our wishes. Along the same lines as number 9, this physician's order for life-sustaining treatment. In some states, it's known as a medical order for life-sustaining treatment. It's a sort of a combination healthcare, power of attorney, living will, and 5 wishes. It's being piloted right now over at Roper St. Francis at their cancer unit there. I can also talk about organ donation. I'll show you a slide on that if you choose to do that. And then also, more and more people are choosing cremation. You need to do a pre-need authorization with your funeral home director or put it in your estate planning documents. Again, cremation for the longest time was not viewed as something that was done normally. It's now probably 60 or 70% of the business for our funeral homes. And we had a safe cremation law. James Jordan, Michael Jordan's dad, was killed in North Carolina, body dumped in a rural county in South Carolina. They took a dental mold, cremated his remains because they didn't have space to store him. And then they realized weeks later that it was James Jordan. And so our state, many states passed a safe cremation law. And again, if you're choosing cremation, you need to get with your funeral home director, get with them now and do a pre-need authorization, or get with your attorney and put it in your estate planning documents. There's a choice there in the 5 wishes document. You can put it in your will. If not, the entire family needs to agree on cremation once you pass, or whoever the person in charge is. It could be the spouse that needs to agree. And then you always want to have somebody advocating for you. This is my mom in the middle there. She was in the hospital about a year before this wedding of her grandson. The hospitalist told us that we needed to let her pass because she was screaming out in pain. Her back was bothering her. Mother of 10 kids, was a college swimmer, and we told her no, her mind is very alert. And we believe if we get an epidural or get a doctor to look at her, she can live longer. And she actually lived another year. So a doctor from the outside came in. So very important that you have somebody advocating for you. On the other hand, I had an uncle with Alzheimer's, and that's a different decision you have to make there. So all tough decisions we have to make as families. And again, back to that Aging with Dignity, that Florida nonprofit, just trying to get us to discuss this, because remember, death and taxes are the 2 certainties in life. I've got this man got run over by a steamroller. Give you a little. Try to give some humor. That's probably not the good thing, but if you want to help others and don't want to bear the cost of setting up your own charitable organization, you can do that through the Coastal Community Foundation. Your churches, your universities, they can all help. We had to devise here $50,000 to help high school students in Charleston County go to college. They were looking at setting up their own charitable trust or foundation. By the time they did that with a CPA, tax attorney, they're going to use up a lot of that $50,000. They simply could go to the community foundation and set it up with no administrative costs. So if you want to help others, but don't want to bear the cost, the community foundation can help you set up self-directed charitable giving. If you have heirs property, and we have a good bit of that in Charleston County and in our coast, the Center for Heirs Property can help you. They help probate the estates to get clear title to the remaining heirs. They're located now in North Charleston, and Reverend Clemente Pinckney was instrumental in getting that right of first refusal. So before an heir sells to a developer, the other heirs have a right to buy. Also take a look at their website. They do free wills clinics, and they used to just serve in the Charleston County area, but now they serve all of the coastal and inland counties of South Carolina. So very useful organization, and they're located again at that opportunity zone up in North Charleston, almost to Berkeley County. If you're looking to hire an attorney, I would advise you to look at Martindale Hubbell or martindale.com. They list all of the attorneys. It's a free service listing all attorneys around the country. And you can look at their peer rating, A being the highest. You can look at their academic credentials. You can see where they're located. And it's by location and by attorney, by name. And this is one of the better ways to select an attorney, A being the highest rating. And again, remember, you're the consumer and you can talk to different attorneys and as far as what their pricing and how they charge. But always advise you to use an attorney. And with Mother's Day and Father's Day coming up, your kids can actually pay for your estate planning. The attorney's duty is to you. So if you've got everything you ever needed, have the attorneys pay for your estate planning, give you that peace of mind. If you cannot afford an attorney, there's a number of services that can help. One is Charleston Pro Bono Legal Services. You can see the way you qualify there. Another is the South Carolina Legal Services. And if you can't meet the requirements for those two, Charleston Legal Access does it on a sliding scale. So you may qualify with Charleston Legal Access. Again, we mentioned earlier, organ donation. Dr. McManus, late Dr. McManus, was instrumental in setting up this Donate Life for South Carolina. If you want to help others, consider organ donation. This California family was vacationing in Italy. Their son was tragically killed, and he ended up, they donated his body to others there in Italy. They didn't really have organ donation in Italy, and he changed the culture there. So just think about that. Elder law, just talk about briefly. If you can afford long-term care insurance, probably one of the better things that you can buy to help you with caregiving at the time needed. I'll run through this again. Long-term care insurance, there are different providers. If you need help with Medicare, Medicaid, I would have you look at the Palmetto Project. It's a free service, and they actually will come to your home and they'll help you with health insurance, with what options, choices you may have. And again, the Palmetto Project, their number is there. Again, they're located in North Charleston, and they can be a very useful nonprofit that can help you. And we also have the South Carolina Department of Aging, and this is a recent change. We now have a Department of Aging that is at the cabinet level, and so Dr. Connie Munn is the director, but they have a number of services similar to the Palmetto Project where they can help you. Along those same lines, the federally funded program is the Trident Area Agency on Aging, and they have a number of programs to help seniors. If you're caring for a loved one, an adult, take a look at the Trident Area Agency on Aging. And then if you need a trustee or a personal representative, a lot of your banks will not be the trustee unless it's $1 million, $2 million. And Family Services, a local nonprofit, kind of fills that gap from $0 to $1 million or so. Again, they do business as Origin SC. And I always remind everybody to take a ski vacation. Any skiers here? Water or snow? That's a ski vacation. That is, spend the kids' inheritance. You never know when you're going to pass. So enjoy life. Never know when God's going to call us. And so, and it may not be taking a trip. It may be helping a child or grandchild with college, or with a car, or with buying their first home, or with some wedding expenses or something like that. And then if the kids are not nice to you, who's got a dog or cat, you can now leave your money in a pet trust. And we've had a couple of dogs here that got $900,000 in trust. Couldn't be kept outside on a change. Any surgery was down to Auburn University, one of the better vet schools. And we had another dog out on Kiowa that got a home. So I don't know if the kids weren't nice to them or they loved their pet that much. So I always tell the younger ones when I see the high school ones to be nice to their parents and grandparents, because if not, they can leave it to the dog or the cat. So keep that in mind. And usually what you'll see, if left to the dog when the dog or animal pet pass, it goes to the local SPCA. Let's talk briefly about wills, probate, and estate administration, and we'll go in more detail at the end here. But generally, there's three ways. If it's under 25,000, no real estate, you can do a summary proceeding. And again, we have a version of what's called the Uniform Probate Code. And it is a national law. It allows different selections in that, and it's typical to many other state laws. The second way is this normal administration. And the process of estate administration is giving notice to what we call interested persons. And then interested persons would be those people named in the will, and those people that would take if there's not a will, who are called heirs. People named in the will called devisees. And we'll see later, we give them notice. And then if they don't object, the probate, most of our probates go through administratively. So we've got heirs and devisees. And then the third party that makes up interested persons are potential creditors. And we give creditors notice by publishing in the newspaper. Again, that notice has to run once a week for 3 consecutive weeks. And then 8 months after that first publication, the creditor's period expires. And the creditor's period is generally 1 year from the date of death or 8 months from the first publication, whichever is sooner. Contested cases, there's a few of our cases. The will contest has kind of gone away, not only locally, but nationally, as this generation does not wait until mom or dad dies to try to get the money. So most of our contests are over the powers of attorney or in trust or joint accounts. Again, you can start with a summary proceeding, then realize you've got real estate, so you go to normal administration. And then if you had some type of creditor's claim or contest, you could do a contested case. And we'll look at more detail and we'll actually walk through a typical probate administration. As far as the state administration, then and now you used to have to come in person. We now have the easy filing. I'm proud to say we're the only county in South Carolina with the electronic filing. We're open 24/7, so you can file at any time. And we also have something for those applying for a marriage license called Love, which is live online virtual e-marriage application. So, and again, we're available anywhere in the world except North Korea. Jamie's working with Dennis Rodman to see if we can get in there. But you can be anywhere in the world and probate in the state. We're trying. And here's there's a fee for easy filing. It's a one-time $7 charge payable to our Atlanta-based computer software company. Again, once you pay the $7, you can file as many documents as you want. By the time you drive down here, pay to park, or by the time you mail things in, we find that very reasonable, cost efficient, and it saves not only us, but saves you time and money. And if you don't have the equipment at home, if you've got a smartphone, you can actually probate your estate on that smartphone, or if you've got a home computer or scanner. But if not, you can go to one of our local libraries, and we've got some listed here. And as a side note, I would tell you to visit our local libraries if you haven't been in there recently. They've all been renovated, and they're just beautiful computer labs, almost like. So I see, is that Becky shaking her head? Yeah, you've been in one. They are nice, aren't they? Extremely nice. And
Beautiful. You're exactly right. Beautiful.
beautiful. So by take time, go to your local library. Here I am up at Otranto in North Charleston, demonstrating the easy filing system. And even I can operate a scanner, a copier, and file documents at the court. So if you want to come down to the court, we're welcome to see you. If you want to save time and money, I'd go to the local library and scan it to us, or scan it from home, whatever works best for you. And again, we're open 24/7. Trust and estates, what do we see coming through the court? Tragically, we lost to Charleston 9. I grew up with Randy and Billy Hutchinson, and over there on the playground west of the Ashley. Unfortunately, we found that many of the first responders at this time thought it was bad luck to get a will to do their estate planning. And they're the ones running into the burning building while we're running out. And we want to make sure all our first responders now have their wills done. So very important that you do your estate planning. The Emmanuel Nine tragically murdered downtown Charleston. They showed us, their family showed us that love conquers hate. There's no violence in Charleston. Reverend Clemente Pinckney is pictured there in the middle. Top right is one of our librarians. The library over there in West Ashley is named after her. But they showed us that, again, love conquers hate. And I was honored to do a probate workshop for their families about 10 days after this event. And I met them at the local library and walked them through the probate process. On the football side, my son's always collecting autographs, and this family, Clay Matthews was the boxing coach over at the Citadel, and they had to reform their trust, so they needed my signature. So I got all their signatures for him, and they needed mine. We just had the Masters. This Charlestonian actually won the Masters. What can we learn from him? Very important that you tell your lawyer everything in your family. A son of his was coming to see him at a tournament. The son got killed tragically in a car accident on the way home. He didn't tell his lawyer about the son or the grandkids from that son. So we had to do a trust interpretation, will interpretation, to show that he wanted to benefit the children of his deceased son. So very important that you tell your lawyer everything in your family relations. This Shoeless Joe Jackson led you through a World Series. What do we learn here? He didn't sign many documents. The one document he did sign was his will. The baseball collector is worth about $75,000. They sued the probate judge and went up to our state Supreme Court. The archivist argued, no, you should keep it with the court. The Supreme Court said, yes, it stays with the court. So if you're famous, your will stay with the court. Countess that started Spoleto used a local attorney. So just keep that in mind. And you can name your living trust, or any trust you have, whatever you like. James Brown named it the I Feel Good Trust, and still in some litigation over Aiken. We'll run through marriage licenses. We used to do about 4,000 of these. We're now up to 7,000 with our Love program, because anyone in the state can use it. Again, live, online, virtual e-marriage application. There is a state mandated 24-hour waiting period. Jamie through this one. And so it begins. I don't like the tone of your I do. No, I should get that one from, but trying to make everybody smile today a little bit. Again, who's coming through? Everybody's coming to Charleston. Dr. Goofy got married here. Some movie stars are coming through. And so we welcome all of those. And Charleston's quite the destination. And this is a local couple that I met a nursing home. What I like about this picture, you can see marriage license division, but look on the right there. You know, get a marriage license. It's also known as the commitment division. So you got to be committed to. Yeah. Let's talk about commitments. What we're really talking about are commitments for mental illness and alcohol and drugs. It affects all of our families. We hope they'll go voluntarily to get help. But if not, we have an involuntary process to get them the help they may need. And the civil commitment process, we have hearings at MUSC, Palmetto, and Ralph Johnson. Again, we're trying to get them the help they need. Now, we've had some high-profile cases come through, and just want to make sure that everyone gets the help they need. Again, we had another shooting, 2 shootings, I think, over the weekend. Mental illness and guns do not mix. Fortunately here for Ms. Boland, I did a civil commitment for her, and she actually had a gun over there at Ashley Hall. And fortunately, it didn't go off, and the families went to the legislature and got it changed. So if you have a civil commitment, you no longer have the right to own a firearm in South Carolina. Again, let's talk about mental health and alcohol and drugs. What you need to keep in mind, there's 2 separate state agencies, one under mental health and one under alcohol and drug. And here are the resources here in Charleston County. again, for alcohol and drug abuse. We've got a new center up there in North Charleston. And for our veterans, any veterans here today? Appreciate their service. Oh, thank you. We actually have a medal for you. We're in person, and we're honored that the Ralph Johnson Medical Center is here in Charleston. Rather large facility named after Charleston private Ralph Johnson, who gave up his life jumping on a grenade in Vietnam to save others. And we've got the new facility up there in North Charleston, beautiful facility that helps our veterans. Thank you for your service, and really appreciate that. Throw this in. This is fentanyl. Drugs are affecting all of our families. And there's a local organization called Wake Up Carolina, and they help with free recovery support. And they also do Narcan training. And you can get certified to administer Narcan. It cannot hurt the individuals if you administer it, but it may save their life. And it's just like using Flonase or you just shoot it up each nostril, and that could actually reverse and save a person's life. Again, the involuntary commitment process, if somebody is a danger to others or themselves, we have a service called Mobile Crisis. They appear on the scene, and they'll call one of our probate judges, may call me, and we're available 24/7 in case someone needs help. And they call us before they're taken into custody. We give them the okay. We have different commitment papers. When I do training for law enforcement, I go through and detail these, what to use. Today, I'll just mention that they're a different paper. But I would say that the involuntary commitment process, we were required to appoint an attorney to protect the legal rights of the person, and a guardian ad litem to look after their best interest, and then 2 designated examiners who testify as to what their recommendation is for the individual. We may hold a hearing, and at that hearing, the judge will determine the best treatment in the least restrictive setting. And we may have inpatient order, an outpatient order, or both, or there may be no treatment needed. And so we had voluntary, involuntary, and now we've got, if you're involved in the criminal justice system, I started some problem-solving courts. The first is an adult drug court. I went down to Miami. Judge Goldstein actually came up and helped us. He was a Brooklyn cop turned lawyer, turned judge, and started the first drug court in the 80s. What we want to do is just get treatment, give people a second chance at life, and get them out of jail and prison and make them productive citizens. Generally, it's a 15-month to 18-month program. They're required to get a job, required to pay for part of their treatment, required to further their education if needed. They have to go to counseling sessions, treatment, and also submit to a urine analysis or drug screen, potentially 6 days a week, and a hair test before they move. We also use incentives to change behavior, and we're not there for punishment, but we do use sanctions to also change behavior. I went out to Seattle and brought back a mental health court. They had modeled it after the drug court, and they use the same tools of drug court, using incentives and sanctions, not to punish, but again, to change behavior. Along those same lines, I started a veterans treatment court. Judge Russell, like me, not a veteran, started the first court up in Buffalo, New York. We use the services of the VA. We also use a mentor system, a veteran that helps the veteran in need. And we have a commencement, and usually at the commencement, we have a speaker. At this one, we had Chief Mullen, and you'll see here, Brian is paying restitution back. Can you guess what house Brian broke into? When you're high on drugs and alcohol, you don't always think right. Fortunately, Brian is alive. He actually broke into Chief Mullen's house. The chief was not home. And fortunately for Brian, but Brian completed the program. The chief spoke that day. and Brian's paying restitution back to the chief. On the far left there, you'll see Judge Hendricks had joined us that day, and she has started a federal drug court in the district court located across the street from us. We've been recognized nationally once by the American Bar Association. Our county in Phoenix, our court in Phoenix, we're recognized for this. I train law students to go out and check on our wards, our seniors under guardianship, to make sure that they're okay, and basically a wellness check. We also are recognized by the National Center for State Courts on our rapid response conservatorship project, generally checking on expenditures in real time. We were selected also with Detroit to do that. Here's another one that slide I just threw in for you. Consider smart911.com. It's a free service here in Charleston County. You can go to it, sign up, and provide them family information, who your next of kin, who you want to contact, any medical information you can provide can be helpful to the EMS person that shows up. So just consider signing up on smart911.com. Again, every second counts. And again, we have online services, and I do workshops, and we record these. If you can't sleep at night, you can watch one of my recorded versions of this, and this one here is being recorded, and you're welcome to go back and look at it. And there's our website. Again, we have free workshops. Jamie Robinson, who's on here and who also emailed you the PowerPoint, gives you my information there. We can ever help, or if you've got another civic group or community organization or church, we're glad to come and speak. And remember to take ski trips, spend the kids' inheritance. As my son Joseph took him to St. Andrews, Fenway Park. The Red Sox, I guess, won a cup today. Is what Patriot Day, isn't it? The Boston Marathon and the Red Sox are playing, and we get an extra day to send in our tax returns. And we went out to North Charleston to see the Globetrotters play. And 2 summers ago, we went out to Oregon and Washington. That's my wife there, Michelle, in the middle, one of the top 10 places to visit in Seattle, called Gum Alley. It's pretty gross, but that's one of the top 10. She liked the one up above, which was the flowers on the left. She got me riding a horse. We went out to see Steve Prefontaine, and we went to the Olympic trials. And on the top right there is Anna Cockrell. She finished third. See anybody so happy to finish third? Why are they happy to finish third? Top 3 get to go to Tokyo, so she made the Olympics. She's Olympian. In the bottom left, Miss Mew there won the gold medal at the Olympics. And last summer, we went to Dublin and presented a portrait of Hoban to the Speaker of the House and President of the Senate in the Irish Parliament. And guess what they have in the Irish Parliament? They've got 2 of these. Maybe our capital could use it. They have 2 pubs in there. Maybe that would help pass the laws and cut down on the getting upset. We also went to the Open Championship, and at Wilmington, we had a good little trip there. We'll have to see what we're doing in 2023. I think for those veterans, we're going to go down to Panama. My dad served in the Army and was stationed in Panama. I always wanted to see where he was stationed. He was down there protecting and guarding the Panama Canal. And let's talk about estate. Any questions on estate planning or anything else that I've covered there? Yeah.
Yeah, I just didn't know how to properly distribute funds amongst the beneficiaries.
Okay. In fact, when I run through this next part, we will talk about that. And if I don't get specific on it, we will. Again, remember this slide we had here. We've got a summary proceeding.
Yeah, and we've done
most administration contested. Okay. Let me walk through each of these. And then if you have a question, we can talk further. This is sort of a overview of the estate that we would have. And you see, we start with a death certificate and go all the way down to order closing the estate or certificate of discharge. The probate process in South Carolina under the Uniform Probate Code is one of giving notice to everyone If no one objects, then it goes through administratively. And at the end there, we would send out what's called closing documents, and we'll take a look at those. And if no one objects, then that's how we would close the estate and then distribute. But we start, of course, with a death certificate. And that's issued generally by the coroner, by DHEC. And that means there's a body involved, they have a body. If there's an accident, and like we had 2 boys drowned on Folly Beach, they found the body of one, not the other. We had a plane crash where they could not retrieve the bodies just off the coast here. We had a sailor that crashed into the jetties, couldn't find the body. If we have an accident, we'll have a court hearing, and in there we'd issue an order, and then they would issue a death certificate from DHEC. Another way, if you go missing for a period of time, now it's 5 years in South Carolina, we can issue an order after that time period. We had an individual hop on a plane, go to Atlantic City, never heard from the family, just one of those unsolved murders. And we had testimony from the family, yes, that every Mother's Day, Christmas, birthdays, anniversaries, he had always sent a card, or he was always there. He's just been missing for that period of time. So he could be declared deceased. Anyway, we need a death certificate. If you have a cause of death that you don't want to have disclosed, say suicide or drug overdose, we'll just take the top part of the death certificate. If you die with a will, it's called dying testate. If you die without a will, it's called an intestacy, in which case the state legislature has written you a will, and basically it goes according to your family tree. Very important also to have a will that has a residuary clause. That's one that catches everything. If you don't, and you just have a will that divides some of your property, but not all of your property, then we'd have a partial intestacy. We'd have a testate estate, but we'd also have to look at the intestacy statute for those properties that were not devised. And the first document we start to probate the estate is this Form 300. It's called an application. If it's a informal proceeding, on the left there. On the right, if we had a contested case or a formal action, it would be a petition. So just keep in mind, we've got a probate form for about everything you can think of. But the main one here is this application to start the probate. If you, I know we have some paralegals or lawyers maybe on here. On the bottom left, and for everyone, you'll see on the bottom left, you'll see different code sections. And so you can go from the form to the actual law down on the bottom left of each of these forms. And then if you go to our website, you can see an index of the forms with the related code section, or you can go from code section to the form. And there's also a subject matter index also. Anyway, here we start off the application. We list some background information. We get that off the death certificate. Let's look at the page 2 of the document, which is under 4A and 4B. Let's highlight those. The people named in the will are called devisees, and we list those under 4A. And the people that would take, if there's not a will, are called heirs. So in my example, we've got devisees and heirs. We've got dad dying, survived by mom and 4 kids. 2 kids take under the will, 2 do not. So, and we'll look later that we give notice at the beginning to both the devisees and the heirs. Just think of it logically. Somebody who could challenge a will would be another family member. People are now spread across the state, across the country, across the world, and they may not know that someone has passed, so they have to be given notice. And we get information regarding the will. If we have a will that's been amended, there's a document called a codicil. Instead of redoing the entire will, you may just change one provision. And then we have an order of appointment, and you'll see that in the middle of page 13. Generally, it's the person named in the will, but you can see that our law is kind of laid out there who's going to be named. On the verification, we're going to verify the information. I would highlight on that verification above the signature there, the last part of that sentence indicates that you hereby submit to the jurisdiction of this court. So if you're out of state, out of country, you're still submitting to the jurisdiction of the Charleston County Probate Court. When we come along, the judge will end up signing a order for informal probate if there's a will, and then informal if there's a probate, and then informal appointment if there's a will. And then if you're named as the personal representative, you don't have to serve, but if you do serve, you then have to carry out your fiduciary duties. We may remember our parents and grandparents actually coming to the court and being sworn in as the executor or executrix, now called a personal representative. All right, let me see everybody's right hand. Let me see if we got an honest group here today. Okay, I need to see the palm of your right hand. Nope, some are taking part. Yeah, looks like we got an honest group. In the old days, if you're dishonest, they'd take a red hot poker and send you a mark in the palm of your right hand. And so that way they know that you. So anytime you see somebody take the oath, that's what they're looking for, is to see if they're an honest person. I did have a guy take the stand one day. He had a mark in the palm of his right hand. I had to ask him about it, but it had a construction accident, so you never know what's going to happen. So that's the application. You'll get 2 receipts, one to open the estate. Maybe you pay 25 or 50 bucks to open it. And then there's a separate fee for the publication. We handle that in-house. You would select the newspapers, and it has to be a newspaper of general circulation in the county, and you can choose which one you like. We then bundle those at the end of each week, send those off to the newspaper electronically. They publish the ad, and we'll look at that a little bit later. And it's published once a week for 3 consecutive weeks. A bond is required, and that's another reason to have a will. If you don't have a will, could be required for an intestate estate. A bond is just an insurance policy that you'll do your job as personal representative. It's calculated on 1.5 times the value of the personal estate. Does not include the real estate unless the real estate is sold and converted into funds. So in most estates do not need a bond. Again, the probate court code has great flexibility. If you're named as the PR, you can renounce your right to serve and nominate someone else. Of course, you can't skip over the alternate that's named. You can also waive bond if you want to. So just remember, in the probate code and probating an estate, there's always great flexibility and probably a form that relates to it. And here's a certificate of appointment. And this allows you to show that you're in charge of the estate. If you think of a president of a corporation, general partner in a partnership, you're the PR of the personal representative of the estate, a separate entity. Yeah, question? Let me unmute you. Oh,
Did that work?
there we go.
Okay, thank you. How long does it take from the time you fill out the application to be appointed as the personal representative?
Oh, once you send it to us, it could take an hour or 2. It could just take that day.
So if you go down to the probate courthouse and you fill out all that, then there's a possibility of walking away that day with a number, a
yes,
case number?
You walk right away with that.
Okay.
If you have everything that's needed, you'll get all this paperwork right back.
And that'll be on the website, what all I need?
Yes.
Okay.
And you want to bring a death certificate, the original will.
Well, my husband passed away without a will.
Oh, okay. I would just bring the death certificate. You'll fill out the application. And since your surviving spouse, you have priority to be appointed. And then you'll fill out the other parts of that too, of that blue form that we just saw.
Okay.
And then you'll is there real estate involved, property
Yes.
involved? Okay. You'll also make a selection on the newspaper there.
Thank
Okay.
you.
Yeah, sorry for your loss, and we're here to help you. I may joke around today, but I've been where you are, and I know it's not easy, so we're here to help you. And we'll have one estate clerk that's assigned to you. I've got one out in medical, but and just bear with us, and we've got one open position, so, but we're here to help you. And if you want to, we'll end up scanning in all your documents and returning them right to you, but you can come on down. And if you want to call and get an appointment to make it easier and make sure someone is available, that's fine too. Because everybody usually comes at lunch, and that's our busiest time, and I got staff trying to eat lunch and people trying to serve, but we're here to help you.
Thank you.
Sure. And you also may be given fiduciary letters. Again, this just shows that you're in charge of the estate. And again, we talked about giving notice. So the time periods are after a person's passed, generally you have to deliver the will to the court within 30 days. Once you're appointed as the personal representative, you have 30 days to send out information to heirs and devisees. Here we are giving notice of the passing of the opening of the estate. And here mom is giving notice to the 4 kids. So she'll provide this proof of delivery. And you'll see the 4 kids are listed. 2 are named in the will, 2 are not. But we have to give notice to everyone. And you can do this by personal delivery, first class mail. You can see the different ways that you do this. The proof of delivery basically just an affidavit that I've done when I've delivered to who I need to, as indicated. 90 days after your appointment, you are to complete what's called an inventory and appraisement. And the inventory and appraisement lists both probate and non-probate assets, though the will and the probate process only controls the probate assets. Okay. And you'll see that many times my example here, I'm just showing, highlighting it. Sometimes the non-probate assets can be more valuable than the probate assets. And if we had a taxable estate, this form mirrors the Internal Revenue Service form 706. Appropriately, we're talking about that today on tax day, but you can mirror that. On the estate tax side, most South Carolinians do not have to worry about the estate tax. It's now an exemption equivalent of $10 million indexed for inflation, which is up to $13 million. And then between husband and wife, we have portability. So we're really talking about individuals that own over 26 million before you have a taxable estate. So we got non-probate and probate. And then you've got supporting schedules behind each of these. And the first supporting schedule deals with real estate. The one thing that I would highlight, the one time the federal government for tax purposes is good to you, good to all of us, is at death. They give us what's called a free step up in basis. And let me try to explain that. If I had bought a piece of property, say 30 years ago, for $10,000, and it's worth $100,000 today, when I sell it for the 100,000, I deduct my cost basis of 10, I'd have a gain of 90,000 that I'd report income on. If I goes through my estate, if I die today, my wife sells it tomorrow for the 100,000, she gets a free step up in basis to my fair market value at date of death. So she sells it for 100, and then her new basis would be the 100. And so she'd have no income. That's why it's important to work with your CPA, your accountant, your lawyer, and when you're putting these values down, because real estate can be in a ballpark, and sometimes people put it on the low end of the ballpark, and they save $6 or $7 in probate fee, but end up spending a lot more on in income tax. So just keep that in mind. Schedule B there, stocks and bonds. Get that right from your broker or from your statement, value at the date of death, cash, notes receivable. An example of non-probate would be this life insurance, where it's payable to the beneficiary. If it's payable to the estate as shown there, then it is a probate asset. But most life insurance is non-probate. Similarly, with joint with right of survivorship property, the joint account with right of survivorship by operational law goes to the surviving joint tenant. This is one area that I'd caution you on. Many times a parent will put the local child on the joint account with right of survivorship to help pay the bills. When mom dies or dad dies, that joint account goes to the local child. If that's what they intended, that's good. But if they intended for all the kids to share equally, then you want to be on the joint account, not as a joint account, but as an account under a durable power of attorney, as an agent under durable power of attorney, because a power of attorney is only good at lifetime, and then when you pass, the will would control it. Again, the joint with right of survivorship, most of our real estate for the longest time was what we called tenants in common, meaning that each spouse controlled 50%. Nowadays, most of it is joint with right of survivorship. So take a look at your real estate deed and see how it is titled. Miscellaneous property, you can just put a ballpark figure down there. And then there's some other transfers during decedent's life, such as a trust. Powers of appointment, this is where in somebody else's will, they give you the power to appoint who's going to receive it when. Retirement accounts, generally non-probate, we name who's going to take those. But if it's payable to the estate, then it can be a probate assets. Encumbrances, we're just going to list what is owed on what we call property that's listed on the inventory, secured interest. We're not going to list the unsecured, such as credit cards. Again, the inventory appraisement is due 90 days after a person opens the estate and is appointed. You look up above there, you see amended. If you later find additional assets, you can amend the inventory appraisement. Or if you need to change the valuation, you can change that. You're not required to get appraisers on the property, but if you have unique property or if there's going to be an issue, then it may be advisable to get an appraiser. And then you'll receive a bill from the court. Again, the fee is only on it's only on the probate assets, does not include the non-probate assets. And in South Carolina, most of our probate fees, as you can see there, if it's $100,000, it's $95. So many times people doing a revocable trust, they may spend more money setting up a trust than they're actually going to save. So most South Carolinians are fine with a will and with a trust inside that will. Again, you'll get a receipt from us once it's paid. We talked earlier about the creditor's notice. This is an example of an affidavit. It has run once a week for 3 consecutive weeks. The first date was April 21st. And so 8 months from that, the creditor's period expires, or 1 year from date of death, whichever is quicker. A creditor's claim will look like this. Again, we caution you to take your time in paying, particularly medical providers. Let the health insurance have time to pay those claims. I know, like my mom, if she got a bill, she wanted to pay it right away. But when you have health insurance, it may take a little while to sort through those bills. This one was filed on a pink sheet of paper. There's a law case up in Greenville. Attorney argued that it needed to be filed. It was filed on a white sheet of paper up there. He argued that it should have been on a pink sheet of paper. Supreme Court said it doesn't matter. So you can use any color that you like. So even though the application is blue and the inventory appraisement is gold, you can use any color. And what we're looking for if a claim is filed is that you've handled it, either paid it, canceled check, or you sent a notice of disallowance. You can disallow the claim. If you're the PR, basically 3 ways you can pay it. You can compromise it, or you can disallow it. And this is an example of disallowance. And then if you're the creditor, you can petition for allowance of the claim. Sometimes they'll wait till the end because if they petition for allowance, they have to pay the filing fee of $150. Normally they'll wait to the end and see if they're going to get paid. And then we've got an order for petition for allowance, which if we had a hearing, we would issue an order. Now, when you get down to closing the estate, one thing you have to do is devise the property out. The real estate It's done through a deed of distribution. It's filed at our RMC office. Again, you want to wait generally until the 8 months of the creditor's period is expired in case you need some of these assets to pay claims. Most of the states, that's not a concern, and you can go ahead and distribute the property. But if you have concerns, if there's going to be creditors out there, the wise course of action is to wait. And again, here's an example of deed. It's considered practicing law, so our clerks cannot help you, unfortunately, complete that. Although many of them probably have experience and could do it. Again, please consult with your attorney. Again, once we do what we call normal administration, there's going to be 3 ways to close it. If you're the sole heir, sole devisee, you can file a verified statement. If there's other heirs, devisees, you can send out the standard closing documents. Or the third way, if everybody will agree, they can waive the closing documents and then close the estate that way. Depends on your family circumstances. Again, here's an example of verified statement. I'm a sole heir, sole devisee. I'm filing this because there's really no one else to give notice to. And I'd like to close the estate. I paid the creditor's claims. If not, we'll send out closing documents. And what we're doing here is basically laying out what we've done as the PR. And if you have an objection, then you'll have 30 days to come forward. And we first start with an accounting, laying out what we've done. We may provide some details, what we've spent and who we paid it to. If we haven't distributed an asset, we'll lay it out on our proposal for distribution. This is what I plan to do. And if we have distributed an asset, we'll have them sign at least a receipt acknowledging that received the asset. We hope that they'll sign a receipt with release with waiver. Many people will balk at this because basically says, here's your asset. And then you have forever discharged the PR for any liability. So many people are leery to do that. But if you're receiving one asset or if you're receiving a sum of money, they may still do that. Again, the third way is if everybody just waives the filing of the statutory documents. And this is an example of this. In a family situation, they may agree that, yeah, a parent is doing the estate. We know it's all going to the parent. We'll just go ahead and waive the filing requirements. And at the end, we'll send out with the closing documents a notice of right to demand a hearing. Basically, we're saying, hey, we've done our job as personal representative. If you have an objection to what we've done, then you've got 30 days to come forward. And we'll also send out an application for settlement. That's what we're sending to the court. Please just check 5C, and that way you can discharge the court. If you add check 5B there, consider and approve the accounting, we may have to have a hearing and go through your different expenditures. And then we'll have a proof of delivery. Your mom will say, I sent it out to 2 kids that are taking. Note that earlier we had 4 kids for the information to heirs and devisees, but remember, on my example, only 2 were receiving. So those are the 2 that we give notice to. And then we'll get an order closing the estate and potentially a certificate of discharge. If you close the estate and you later find additional assets, you can do what's called a subsequent administration. To do subsequent administration, I know they came up with the fee, but it's $22.50. It doesn't reopen the creditor's claim period, but it allows you to reopen the estate. Maybe you find some unclaimed asset at the treasurer's office or some stock certificates. I want to reopen the estate. Again, if you get behind on filing any of these documents, please let us know. You can ask for an extension of time. If you get behind, we may send you a friendly letter, and then a second friendly letter, and then the third letter basically saying we may have to have a rule to show cause. So just keep that in mind. We're here to help you. If you ever need an extension, we just need something in writing. Either use the extension form, probate form, or just send us a letter or an email. And that was very quickly over estate planning and probate. Any questions? Must have some questions. Yes.
Do you have to specify when, because I'm doing the waiver of statutory requirements, that's what I need to do right now. Do you need to specify for the different, it's my uncle and 2 cousins and my dad. Do you specify who gets a certain percentage of the inheritance?
You had a will, or y'all are agreeing among yourselves?
We're very close family. We're agreeing among ourselves. So they're gonna sign it. My dad's the
Yeah.
PR.
Yeah, I would lay it out. That's more a private family settlement agreement. I would lay out who's getting what.
Okay.
And be very specific who's getting what, and then make sure there's some consideration in there, and then
Okay.
have all of them sign it. Yeah.
Okay. That
And they
sounds good.
can- Yeah, they could also sign these waiver filing requirements too. Okay,
Sounds good. Thank you.
sure. Good luck with that. Do heirs need to sign the waiver? Yeah, everyone would have to sign the waiver. But if you have devisees, the heirs wouldn't be takers, so it'd just be whoever the takers is. Yeah. Okay. Other questions, concerns? Anything to help you with?
Okay, I posted a question in the chat
Okay.
about our bus loan.
Let's see. Make sure I got it.
Read it out, Jim.
Is your question about all the heirs need to sign the waiver of the accounting?
No, it's the next one down.
So it says, we have a loan secured by our house, which is in my deceased wife's name. Does typical lender leave the loan in effect while I continue paying?
Okay. So there's a mortgage on the house and you're still paying it.
Yes,
Okay. Yeah, I would just keep track of what you're paying, okay? And
okay,
then when you do the accounting, you could give you a credit for what you've paid.
okay.
Is somebody living in the house, or how are you?
Yes, I am.
You are, okay. It's advantageous to have somebody in the house because that helps with the liability and fire insurance and all of that.
Mhm.
The others may argue that you got to pay rent, so they'll just need to work through that. Yeah.
All right. Is it best to inform the lender that she has passed?
Yeah, you're probably under duty to let the lender know that they've passed. But if somebody's making the payments, they're going to be happy. The mortgage will run with the property. So whoever gets the property is still going to have to take it subject to the mortgage.
All right,
So that's their security interest in the property. Yeah.
okay.
It wasn't any type of reverse mortgage, was it?
No, it was a consolidation loan secured by the house.
Okay. So typical 15 or 30-year mortgage.
Well, 8 this time.
Pardon?
We did 8 years.
8 years. So accelerated 8 years. Yeah. You have to look at the documents, if somebody could assume that, or whether it triggers some payoff that you have to make now.
I see.
Yeah. So I'd look at the documents, maybe also talk to an attorney.
So
Yeah,
we have to
thanks.
do this.
Sure.
So with somebody first.
I have a question.
Sure.
As the PR, am I responsible for evicting anyone that's in the real estate owned by the decedent? If we're trying to settle, am I the one that's responsible for doing the eviction, or would that be somebody else?
That would be you're in charge of that.
Okay.
And what you want to do is kind of ask them nicely, or come to some arrangement where they're living there until the property is sold or deeded out. I'd ask nicely, send a letter.
I
to them.
did.
They're still staying?
I did. They just said they don't think they have to move, that they're a grandchild of the decedent, so they think they're an heir, and I'm explaining to them that they're not. They're like, I don't think I should have to move. So
Okay.
yeah.
Yeah, I would consult your attorney, and then you may end up
Yeah.
in magistrate's court or small claims court to have them evicted. Yeah. I'd talk to your
Yeah.
attorney.
Okay. Okay, thank you.
Sure.
Judge Condon,
Yes.
when you have no will and 3 adult children, is there a way to help your mother reduce attorney fees if the 3 children just agree she's the personal representative, everything goes to her? Is there a way to just have the attorney have to work on that private settlement document that you
Yeah.
that you talked about, and the
Right.
deed, and whatever the deed, to get the deed just in her name, and then we do the rest of the forms?
Yep, you can do it that way. You can do it à la carte. I just talked to the attorney. And
Okay.
yeah, you could do the private family settlement agreement. The attorney could do that and do the deed. And you potentially could handle the other documents.
Ourselves.
Yeah.
Okay.
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 Just get the attorney to hopefully agree to do it that way. Yeah.
Okay.
Yeah. And you want to make sure when you're doing that, that you do a private family settlement agreement. If you do what's called a disclaimer, then it goes from whoever disclaims down to their children. And that's
Okay.
generally not what you want. You want it back all to mom.
All right.
Yeah.
Gotcha.
I just have one last question.
Yeah.
My cousins and uncle are all out of state. Some are in Detroit, some are in Georgia. Do I need to get them, because it's a South Carolina notary that needs to sign off on it? How?
It can be a notary in their jurisdiction, I believe.
Their
Yeah.
district, and that's fine.
Yes.
Just, maybe just edit the document that just says it's, or just get them to pull up what their
Yeah.
state document is.
Yeah, I would just have them do a separate one. And
Okay.
then they can line through the South Carolina part and put whatever state they're in.
Okay, thank you.
Sure. Other questions, comments? Anything help you? Let me give you my numbers if I can ever help you. They're back here. Here's my direct dial number, which is this 958-5193. And my cell is 817-2039. And then my email address is irvcondon@charlestoncounty.org. So if you get a question or something comes up, give me a holler. Only caveat there, if it's a contested case, I really can't help you because I got to be the judge and I can't be the football coach on one side and the referee. Okay.
Thank you so much for your help.
Sure. Glad to help. Again, we're here to help you.
Thank you.